Welcome to Sorainen webinar on mandatory merger filings in the Baltic countries. My name is Kaupo Lepasepp. I'm partner in Sorainen Estonian office and I work in the commercial and regulatory team. During the next 2 hours, our best specialist on different mandatory merger filings will give you an overview of the landscape in the Baltic countries. We start with the new kid in the block, these so-called FDIs, foreign direct investment filings. It's FDI, not FBI. They sound similar, but they are completely different things. Foreign direct investments, they're new kid in the block. We give you overview of how they are implemented in the Baltic countries, what is the future impacts and where do we see concerns. Then we visit our good old friend merger filings. They've been around for a while, but the landscape is also changing. Rules have changed, practices have changed, and sometimes also people have changed. So we give you both practical and also legal, overview of the legal framework. And last but not least, they say that 2 is a company, but 3 is already a crowd. And mandatory merger filings landscape might get pretty crowded if a new entrant comes to the play. So these foreign subsidies, regulations and potential filings. The team has specifically prohibited me from giving you any spoilers or any overview what they will tell you, but I've seen the slides and I've heard the preparations for the conversation, so be ready for some really nice treats down these 2 hours. Before I give floor to the first speaker, I will remind you all that this event will be recorded and we will be sharing it with you, and we will be sharing in our social media and YouTube accounts as well. But this doesn't mean that you all can now leave, but this actually we still encourage you to attend and participate actively, ask questions and participate in these discussions. We have received few key questions beforehand. Thank you for that. But during the event, you can ask questions in the Q&A box on the. You should see a button on the right hand side. We do our best to respond to all your questions, either orally or in the chat, but we will see in reality whether we can accommodate all the questions. And if something leaves, some questions remain open, you're always welcome to reach out to our specialists. Their contacts will be in the end of each and every presentation and also afterwards shared with you. But now, before we go to the fully legal part, we also start with our first discussion coming from Riga, where 2 hands-on specialists give an overview of how actually in-house legal departments and in-house lawyers see the landscape of mandatory merger filings. So the first block will be discussion with Tatjana Čaika, head of Bitė Latvia legal department. And this conversation will be moderated by Marika Grunte, our competition guru from Riga office. So with all this, please, Latvia, take over the attention and take over the spotlight.
Thank you, Kaupo, for introduction. Good morning to everyone, and I hope we will not let you down with our discussion here from Riga. And as Kaupo mentioned, today we have a guest in our Riga office. It is Tatjana Čaika, who is head of legal of Bitė, and yes, and I'm Marika from Sorainen, and we will have a brief chat today with Tatjana about merger filings and FDI filings, and on one hand, Bitė is a very good example to give insider's view, because Bitė Group is quite a big group operating in different markets, from fixed and mobile telecommunications and ID to TV and radio. And as a big group, they have, of course, on several occasions seeked these filings, both from a merger perspective and also FDI, and therefore I would like to ask Tatjana to share her experience about how it has been, and yeah, maybe you can tell other parties some of your experiences.
Yeah, hello everybody, and thanks to Marika and to Sorainen for inviting me to participate in this event. Actually, it's my first webinar and the first time I'm being interviewed in such a format, so a very interesting experience, and I'm very happy to share our experience working from Bitė and facing with both merger filings and FDI filings in our day-to-day lives. It's not like very often happening, but back into the 2017, we had a really big deal, the merger, which was one of the biggest probably in whole the Baltics. And Bitė Group was acquiring media holding MTG. And in this holding, you may know the such channels which are over the Baltics, TV3 channel, which was the most popular during that time. And also the second biggest channel in Latvia, it was LNT, and a few radio we also were acquiring during this transaction. And actually it was very unique from the different perspectives, because this was the first time we faced really the FDI filing, and this FDI filing was even without the specific regulations. So we had the requirement by the law, but there were no specific the regulations of the Minister of Cabinet to understand what we should file and what information should be provided in that notification. So another first time in this transaction was that the merger filing was reviewed by the Competition Council even longer than it is provided by the law. So we have the maximum term of 4 months for the very complicated transactions, but this time it took almost 5 months, which was also like extraordinary. And the first time was that this notification required also re-notification of the previous transaction, which was done by the MTG in 2012 year. So a very complicated task was faced at that time, and maybe I can share the experience in more details, like that re-notification which was required. So the first time Competition Council gave the merger clearance for the definite period of time. It was 5 years, and it was in the transaction between TV3 and local channel LNT. And both
TV channel, yes.
Yeah, TV channel, and both was the biggest in Latvia, and both were acknowledged like the dominant channels in the market. And that's why Competition Council want to be sure, and they put an obligation in 2017 to revise this transaction, to check either the competition is impacted by that transaction or not. And despite of the fact that our Bitė Group was dealing only with telecommunications and no media was in our concern, we still had to provide this notification to the Competition Council. And this requirement was of course, because the thresholds were met, but from the one hand, there was no like increasing the market share in the market, but still it was very complicated, and it took a lot of time for the Competition Council to decide on our transaction. maybe.
Yeah, and so if you compare notifications in Lithuania and in Latvia that time at least, was there some major differences between those? Because also in Lithuania, I understand FDI was required in both countries.
Yes, FDI was required in both countries, but as soon as I know, as far as I know, that in Lithuania there was also almost all regulations met and prepared at that time. So we just took the experience of our Lithuanian colleagues and provided all the information they gave to their authorities to get the permission. And in 2017, we just got this new law of the national security law, and of course Bitė as one of the biggest telecommunication providers was acknowledged as an important company for the national security, and we had that obligation to notify the deal, but we didn't know how to do it, what information should be provided, and so what we did, we just put in a very detailed way the scheme of our group, all the chains, how we are connected, and as our main investor is American investment fund Providence, we just provided step by step all the companies which are within our group, and it took 2 months to get the clearance from the Cabinet of Ministers at time, which was of course faster than it went with the competition clearance. Actually this was like the first and the last time when we had to notify the FDI filing.
Okay, and since we are like touching upon both types of filings, maybe, and since you have experience with both jurisdictions, maybe you have some view on whether there are some unreasonable requirements or practices which are related either to foreign in these investment or merger filings, which you think should not be there.
Of course, I will more speak about Latvia, but speaking generally about the approach which is in Lithuania and Lithuanian state authorities, I see that in Latvia we have more bureaucracy. Maybe we have less strict rules, but the application of these rules is very, how to say, it takes a lot of resources, and the state authorities are thinking less about the businesses, but they are thinking more about the compliance with the requirements which comes from the legal regulations. But talking about specifically Latvian situation with the FDI filings, what I see, which is like maybe too much information is provided to the state authorities, and it would be more efficient that we shouldn't provide this information several times to the different authorities. However, this is the same by its nature, the same information. And to give the exact example, so in 2017 we had this FDI filing. So the responsible authorities, the Cabinet of Ministers, took a decision that they are giving us the clearance of the deal, they know the chain. They acknowledged that the Providence is investor, is a reliable investor, and it doesn't make any concerns regarding the national security. So we got this clearance. After that, each of Bitė companies which is acknowledged as important for the national security need to provide a filing to the Ministry of Economics with basically the same information. So we had to notify from Bitė Latvia, we had to notify from each of the media companies. Third time, well, actually it was like the basic requirement that each of us need to provide the information about the ultimate beneficial owners and to register them in the state company register. So we did it, and during this filing, during this registration, we also were requested to provide very detailed information with all documents from like the extracts from the state registers of every company which is in our chain from every country. So it was like, I don't remember, like 15 extracts. So we gave it to the state company register, we gave it to the Ministry of Economic, we got the clearance from the Cabinet of Ministers. However, all this information could be like stored and shared between state authorities just once. And also now, in case of Bitė will be willing to acquire a new company, which is important for the national security, again, despite of the fact that everything is checked already, we need to provide this information one more time. Of course, the clearance by itself is very fast, and we don't see any concerns in general about this, but still it's not that necessary. And
so basically the takeaway or advice to the legislators, hoping that someone of them is also participating as a listener today, is to think about how to do things more efficient, so that if companies have already provided information which is already stored in public databases, then use access to this information instead of requesting it once again from the market participants. Okay, we have 2 minutes left in our part, so maybe to conclude this short discussion, maybe you have some good advices for the parties who are eventually facing or considering a complicated merger filing, and eventually where remedies could be also requested. What would be your advice in such case? To stop it or to go for it?
Of course, to go for it. So, but two very important things for everyone who is filing for the merger clearance and also for FDI clearance is the close cooperation with state authorities and proactive behavior. So you need to be ready to communicate with state authorities, like you are providing information, you are requesting how they look at it. Go and proactively check the case materials until the end of the whole process. So you already will know what questions are asked to the other market participants. You will already know the answers. So you can predict the conclusions of each of the authorities, and you can predict either any remedies could be applied, and also think proactively about remedies, what you can provide to the state authority. So it's not the surprise for anyone, both for the Competition Council, for you. So you're providing the keynotes for the authority, and you are giving them already the ready material to work with, and you will also know either you will be able to complete all the remedies or not. So
okay,
cooperate.
Excellent. I think this is a very good advice, and please listen to it. Don't get afraid if you are facing a hard transaction, because you just got a very good advice from Tatjana. Thank you very much for joining us today, and I give floor back to colleagues. Kaupo, maybe you can introduce the next part. Thank you.
So thank you, Tatjana and Marika. It was a good discussion, good insights, and also good encouragement that the additional red tape and practices, they're not actually preventing good things and good deals from happening. So now, when we know that we shouldn't be afraid of the monster, let's zoom in. What is the monster? And the next topic will be overview of the foreign direct investment regimes in the Baltic countries. We do it country by country, and my understanding is that we start actually from Lithuania. And this is my pleasure to introduce you my colleague Matas Mačiulaitis from Sorainen Lithuanian office. Please, Matas.
Hello, everyone. Let's start from the south. My name is Matas. I'm Senior Associate in Sorainen Vilnius office. And today I'm going to introduce the Lithuanian FDI controls, which is governed by the law on national security, which I think might be one of my favorite laws because sometimes it raises more questions than provides answers. And I believe that is why they invented lawyers. So let's have a look. Who are the investors covered? The regulation applies to all investors, whether Lithuanian, from the European Union, or third countries, acquiring or investing into 25% or more of the shares or votes in the company. We're going to talk about which companies are covered soon. So as you can see, there is no political or geographical qualifiers for the investor or acquirer. There is no really materiality threshold for the investment itself. So it seems that there is no escape from the regulation. But there are a few exceptions. For example, if the investor is a member state of the EU or member of the NATO, OECD, or EFTA organizations, or is a company at least half owned by such organizations, then this investor is automatically considered cleared. The same applies to international financial organizations, of which Lithuania is a member. And there is a third exception, which is a bit more peculiar. It sounds like that. An investor operating on a long-term basis in one of the mentioned jurisdictions and having experience in the relevant field. Now, because the law does not define what does it mean long-term basis or having experience, and because the Commission can still later on decide that the investor is actually posing threats to the national security, we normally advise to ignore this exception and just play it safe. Now, who are the companies covered? There are basically three big groups. Companies operating in economic sectors important for the national security, companies operating in the protection zones, or companies explicitly listed in the law as important for the national security. Of course, there can be cases where one company is in two or even all three of these groups. Let's start from the one we deal the most with in practice. Sectors important for the national security. We have 5 sectors listed in the law. All of them have their own subsectors also listed in the law. Most of them are more or less straightforward and clear. For example, generation of X amount of electricity per year or construction of bridges. We do have some issues with IT sector. IT sector has several subsectors. I'll name you one, other software publishing. As we see it, a big chunk of Lithuanian IT businesses fall in this subcategory, meaning that no matter how old or young, how big or small the company is, if you are investing in such IT business, you will probably need to file the FDI application. The other group is companies operating in or nearby protection zones. Those I would say are pretty standard, like railways, seaports, airports, fresh water supply, nuclear power plant, other energy objects, and data centers. There are some other also objects in the law. There's also a perimeter around these objects that is also considered a protection zone. The third category, and the one that we deal with the most rarely, I would say, the companies explicitly listed as important for national security. Those are basically fully or partly state-owned enterprises, like operator of the airports, our big energy company Ignitis. But there's also some exceptions. For example, Polish petroleum refinery Orlen is also in the list. Now that we know who are the investors and companies covered, let's look at other key aspects of the FDI regulation in Lithuania. FDI screening is mandatory when mentioned companies or investors are concerned. FDI filing obligation lies with the investor. Approval must be obtained prior to closing. The main task of this whole process is to show who are the UBOs of the investor and provide the chain of companies leading from the investor to the UBOs, as was already mentioned by the previous speakers. The very detailed documentation proving the chain also has to be provided, and that can take time. But the clearance normally takes 1 to 2 months. We Most of the time we do it in 1 month. The procedure is confidential upon request. Failure to clear the investor can result in the transaction being declared null and void. But on the plus side, there is no filing fee for the application. Now, the possible outcomes of the procedure. The investor, of course, can find that it is meeting the interest of national security and the transaction can take place. Before that, some recommendations can be given by the Commission, and we have to meet those before we complete the transaction. Or the investor is found not meeting the interest of national security, and the transaction cannot take place. But I don't want to conclude this presentation on this low key, so I'll give you this a little statistic I've made. In Lithuania, at least in CMA group, we have so far this astonishing 100% FDI filing success rate. So no matter do we call it a monster or not, we can deal with the monsters, I guess. And of course, here I'll have to give credit to our knowledgeable colleagues and our clients, which are of highest quality, I can say. But also, I dare to conclude that since the regulation is still quite young and has those questions that we are trying to solve and answer, the Commission sees that, and it also is cooperative and helpful. So with that, I thank you. And next up, Latvia.
Yes, good morning. Good morning. My name is Nauris Grigals. I am partner at Corporate and M&A practice group in Latvia, and I will be introducing you to practicalities and general information about FDI regime, which is applicable in Latvia. So in Latvia, this FDI regime, basically, it's similar as in Lithuania, as you just heard, and basically it is applicable to the companies which qualifies to the certain categories which are listed in the law. Currently, I will not in detail go through all of them, but basic principle is if the company qualifies for this category, the FDI clearance or national security clearance is required and it shall be received. And in that respect, also similarly as in Lithuania, it doesn't matter very much who is the investor, what's the geographical location of the investor, what is the political background. There's also no monetary thresholds or similar. So what are the companies? The companies we can basically list in several major categories. One of the companies which qualifies under this regime are owners of critical infrastructure. And those objects which are considered as critical infrastructure are determined by the Cabinet of Ministers. The second large group is electronic and electronic communication companies and electronic mass media. Of course, they have to qualify to certain thresholds which are determined by law, but that's the other group. Second, very large group are basically companies operating in energy sector, but not all of them. Basically, they are transmission system operators, certain energy producers, which exceeds certain capacity of 50 megawatts, etc. Then there's next group of companies are owners of the land, forest land and agriculture land exceeding certain area. Then the companies, there are dual companies which produces dual use goods according to the mentioned EU regulation, and some other which are maybe a bit more specific to Latvia, but basically companies which operates with significant or sensitive data. According to Latvian process, very shortly, the company which qualifies under any of these categories, it has an obligation to notify on this Cabinet of Ministers and Commercial Register. So basically in Latvia, we can check in the register whether or not the company qualifies under this regime. And of course, the company has to provide certain information to the Cabinet and to Ministry of Economics, information on its shareholders, information on its ultimate beneficial owners, etc., etc. If the company fails to do it by itself, but let's say the Cabinet of Ministers or the Ministry of Economics establishes that this company should be registered as company significant to national security, then those institutions can impose the obligation on this company to comply and to submit the relevant information. Next slide is basically what are the transactions which are subject to FDI clearance and which shall be notified. There are basically 5 types of them. First one is acquisition of qualifying holding. That's 10% shareholding. And second one is acquisition of decisive influence or control. That basically means 50% plus 1 share. What has to be pointed here specifically, this relates also not only to direct shareholding, but also to indirect shareholding. So this is very often applicable in Latvia, that there may be transactions which actually do not happen or are not concluded in Latvia, but are concluded abroad. But if those, as a result of those transactions, the qualifying holding, indirect qualifying holding or indirect decisive influence changes in the company in Latvia, this transaction also has to be notified to the Latvian Cabinet of Ministers, and FDI clearance has to be received. Then the third type of transaction is transfer of undertaking, so business is going concern. That is also, so to speak, company can transfer its significant assets. If the shareholder changes its ultimate beneficial owner, that also has to be notified, and receiving loan, that's specific, which has come lately into the law. Specifically, basically, neither person from Russian Federation or Republic of Belarus can acquire company significant to national securities, and there are certain exceptions, but they are basically not applicable to ordinary M&A transactions. They are very specific. So who is requesting the permit? Basically, in transactions, that's the person which is acquiring the applicable threshold. So it will be the company which is, simply speaking, the acquirer in M&A transaction, either acquiring directly the shares or shares are acquired indirectly. In case of change of ultimate beneficial owners, that can be a shareholder itself. In case of transfer of business or receiving loan, the company which is transferring this business or receiving the loan has to apply to receive this permit. The general principle is that this application and clearance has to be received before completion of transaction. There is one exception, as you see, in case of change of ultimate beneficial owner, but usually this also comes together with acquisition of qualifying holding or decisive influence. Therefore, the clearance has to be received before closing of the relevant M&A transaction. Procedure, very shortly. All documents have to be submitted to the Ministry of Economics. Certain information has to be provided, detailed information on transaction. Reasons for transaction are advisable because at the end of the day, the ministry may request also to submit all transaction-related documents. Ownership chain has to be provided, basically showing up the full group of companies which is intended to be the new group of the company in question. Information of ultimate beneficial owners. In certain cases, which falls under the EU regulation, also information on business activities and annual turnovers of the group companies. And as I say, additional information may be requested. Decision is usually, has to be adopted within 1 month, but this deadline have to be extended up to 4 months. And there are basically 3 different types of decisions. Either transaction is permitted, transaction is prohibited, or transaction may be permitted with certain restrictions. And the lastly, consequences of non-compliance, very shortly. Basically, in the Republic of Latvia, this transaction will be considered as null and void, and it will have no impact in Latvia. the decisions in case of acquisition of shareholding, all the decisions of shareholders meeting will be null and void, and the shareholder will be prohibited to vote and participate in shareholders meetings of the company. This is shortly about Latvia, and now I will hand floor to my colleague Lauri from Estonia, who will continue regarding Estonia. Thank you.
Hello, I am a counsel and a member of our Estonian M&A and corporate team. And I will speak about this new foreign direct investment regime in Estonia. So in Estonia, we are in a slightly different situation than in Latvia and Lithuania. We are a bit behind because the regime was adopted only at the beginning of this year, and it will be in effect in 1st of September 2023. And so 1st of September this year. So obviously we don't have any experience in this, but we can talk about the regulation. So the primary objective of this regime is to screen this both direct and indirect investments made by non-EU investors in strategically important and sensitive areas. So I would say this is the main difference with Latvia and Lithuania, that it is limited by the investors who are non-EU investors. So basically not all investors are included to this. And also we have to look at not only non-EU, but also the EU economic area investors have to apply for this to be compliant. So who are the investors who should apply for this? So the investors who are natural persons who are holding citizenship of a non-EU state, or who hold like several citizenship, which is one of these non-EU states, or any natural persons who don't have any citizenship. And it doesn't matter where they live or where is the residency. It is related to their citizenship. And it also to the companies and undertakings who are under the law of established under the law of a non-EU state. And also these undertakings controlled either by natural persons or undertakings or companies from non-EU states. So it means that in case in Estonia, we have to look at first who are the owners of who is the investors and who are behind the investor, who are the UBOs basically. If looking at the targets, I guess it's quite similar than in Latvia and Lithuania. Maybe the list is populated a bit differently. There are like 11 group of target undertakings, providers of vital services like gas, energy, mobile or data service providers. Undertakings holding special licenses of geological exploration, state-owned companies, other companies who have agreements with stockpile contracts, and military good, defense sector, and television and radio broadcasters. This is only about 3 million turnover at least. And yes, also this communications, broadcasting, transmissions related companies. And also railways, airports, seaports, all these kind of companies are listed there. And then if looking at the statistics, who will be affected in this regime, is that it looks like it mostly there are about 170 companies who are providers of vital services, and also these state-owned companies and also these stockpile companies. It looks like this obviously there are like railway infrastructure managers and the airports. There are like very few of those. But all in all, it looks like it's counting the 300 or something companies. What transactions are covered by this regime? Well, it has to be also like in Latvia, it is a director indirect qualified holding, and the qualified holding is 10% of the company or the share capital, or having a significant influence, or this is direct control over the undertaking, meaning having the voting rights, etc. And also this applies to the part of the undertaking of a company. If you're buying a business or part of the business or assets of the company, which is the target company and the relevant assets. And also we have to keep in mind that when buying or acquiring 10%, then when acquiring control, then you have to have this or apply this authorization for the second time. So what are the deadlines for the process? So the main deadline is like 1 month, 30 calendar days. The application needs to be signed digitally with Estonian digital signature, meaning that actually investors who are outside or non-EU don't have this probably, so they have to authorize somebody in Estonia to do this for them. This application is submitted to the Consumer Protection and Technical Regulatory Authority in Estonia. If after 30 days says approval is given or not given, or it can be extended up to 90 days if there is seen that more time is required for the decision. There is no specific requirement, so they can quite easily, I think, extend this period. And if there is this need for to apply any additional conditions for the acquirement of this share, then they can impose set additional 60 calendar days time, and for the negotiations of any commitments to be taken by the company. Well, it could be like a transfer of shares in a target undertaking, continue performance of pre-existing agreements, etc. What are the main evaluation criteria? Well, they will look at about the investor, of course, the country sectors of which investor is active and who is controlled by it. The economic activity of the target, of course, important. They look what intellectual property is owned by the target and financing. So they will ask you quite a lot of information about the company and itself, the target and the investor. So in Estonia, the target company don't have to register it anywhere, so it has to be each time looked at whether this regime applies or not. So the consequences of non-compliance. If the transaction is done without this approval, then the shares has to be transferred back, or the transaction has to be reversed, and then make any other actions that are required to restore the pre-investment situation. And also levy can be imposed up to 100,000 euros, and then this can be imposed repeatedly until the order is complied, so the old situation is restored. It does not, the law does not specifically say that the transaction will be void, but I think it's a question and future practice we'll see. But anyway, it has to be reversed. So yes, I think that's it from Estonian side of the regulation. So we thought that we will discuss a bit about the impact of the filing requirements for the M&A activity, and this goes for all the Baltics. Sorry. Yes. So my colleagues Matas and Nauris will support me on this. But what are the transactions are mainly is purchasing shares or another company, creation of new company with consolidation, merger, acquiring any assets, etc. So the main notifier is usually the party who is notifying is a buyer or acquirer share, and the regime is different in any country. So in case of transaction, it has to be carefully looked at it whether the approval is needed also in other countries and not only in the target country. And it is similar that it cannot be completed before the transaction is cleared. So there is standstill obligations, and yeah, it's basically that it has to be obtained prior to the transaction. So Nauris, do you have any other general comments on this part?
Yes, maybe a bit general comment and a bit specific. As Lauri said, you cannot complete the transaction before receiving a clearance, and in Latvia there are also mechanics that those notes about the qualification of this company to this status are also made in shareholders register. So you actually, assuming that the board complies with law, you actually cannot really even execute this transfer of shares before you receive a permit, because the board is prohibited to make relevant entries in the shareholders register before this FDI clearance is received. Matas, do you have any comments?
Yeah, it's similar in Lithuania, but I have seen actually cases where the FDI application is submitted after the transaction is completed for, I don't know what was the reason for that, but it can happen in practice. We, of course, do not recommend this way, but you can try and get the investor cleared even after the transaction. But of course, you take huge risk of failing to clear it, and then the transaction is null.
Okay, thank you. So what is the main impact? Of course, now we have to consider the identity of the buyer, especially in Estonia. I understand that in Latvia and Lithuania it's not so important, and it's anyway under the regime. We have to identify who is the target and nature of its business. So we have to make sure to understand whether this approval is needed or not. It has to be taken, yes, a level of stake or control to be acquired has to be taken into account. And we need to look at this, the share purchase agreement or any other agreements that is involved or related to this acquiring part of the shares of the company. And also the timeline, of course. Since there is, it has to be, basically at least in Estonia, it has to be, the application is to be submitted after signing of this binding agreement and before closing. So there will be standstill obligation during this time. It's basically the same as in the merger clearance. There signs agreement and then submit the application and then wait until approval. So yes, there is, and then of course, if this time period can be extended by the authorities, it has to be taken into account. And of course, there is a bit less legal certainty of the closing of the transaction, because it's at the end it's a discretion of the decision-making body whether they give approval to this or not. Okay, Nauris, do you want to add something?
Yes, again, maybe a bit on more of specific side. For example, for Latvia, we have this registration requirement for the companies, but in any case, the company and its activities, the target company, should be evaluated. Just because the company hasn't registered itself as this company important to national security, it doesn't void or cancel the obligation for this clearance. So in any case, this target company has to be evaluated, and of course, you have to remember that you have to receive this clearance before you close the transaction. Matas?
Yeah, about the registers and list of companies, we have a situation in Lithuania where we have those sectors that actually can apply to so many different companies. It's not possible to give you a count of companies that fall under this regulation, and that's why sometimes we have those strong discussions internally where we try to argue why this FDI filing should or should not be completed, because some subsectors are not clearly defined, and it's sometimes hard to get the right answer. So what we do, we try to play it safe. If we don't know for sure, we say let's better do this filling and just sleep, tight during the night. And that's actually the same answer that the Commission provides, because we do have those contacts. We try to ask them what do they think about certain situations, and they always say, guys, just fill the application, and it's not that hard. It's for free. It doesn't take much time, so just do it, and everything will be good to go. And actually, about the synergies of the procedure, I do find a lot of synergies, because we do have those relatively new rules of registering the UBOs, and the documentation that we have there is very similar to the one that we use for this FDI filling. So when you collect the documents on the ownership structure, ownership chain, you can always try to shoot two rabbits with one shot.
May I also jump in with a question regarding foreign direct investments? I understand that it's a usual income, especially in our Lithuanian office, is that all the notifications end with the results that the investor meets the interest of national security. But now turning especially to Latvia and Lithuania, which have laws in place and practice also in place, do you have kind of any guidance or any decisions where actually it is just understand when an investor would not meet the interests of national security? I mean, of course, let's say in Latvia, if you are a Russian citizen or Russian-controlled company, then it's very straightforward. But let's take an average OECD country. What you should be afraid of, what you should not be afraid of. I mean, what are the reasons when an investor can be found not to meet the interests of national security? National security usually it's not very transparent. It's rather, let's say, opaque. Also, the reasoning. Do you have any experience in the market or any guidance? What kind of investors should be worried?
Well, answering with respect to Latvia, of course, this process is not transparent at all. First of all those processes are confidential, so we kind of cannot see the overall statistics of how many applications have been submitted. And second of all, in practice, at least, and also according to the law, the cabinet, when making a decision, greatly relies on reports from national security institutions. This is security police and similar. So basically, the process is whether or not those security institutions clears this transaction. We know from practice that basically, let's say, mostly all the transactions are cleared. I know personally, but I'm not sure whether I can disclose. There has been at least one transaction which was not cleared, but that was mainly due to the, so to speak, personality and location of the investor. So I guess location of the investor would be the most critical point which has to be evaluated before going forward.
Okay, but very briefly, how is from Lithuania?
Yeah, Lithuania is very similar to what Nauris explained about Latvia. The procedure is confidential. We don't know, how do they decide that. If you are an investor and you committed crimes, or if you are connected to unfriendly entities, it'll probably not going to be cleared. So this is in the law, but there's also a statement saying that the Commission can decide that you pose other threats to national security. And what does that mean? No one knows except for the state. So yeah, you should be mindful about that. But in Sorainen, we were lucky or prudent enough to not have those cases actually. So we don't know any bad examples.
Okay, thank you. It would be very interesting to continue the conversation from here, but unfortunately, time pressures us. So thank you, Matas, Nauris, and Lauri for this overview. And then with that part, we close the chapter on foreign direct investment. and revisit our good old friend merger filings. So now I give floor to our best competition law specialists, and this time to shuffle the cards, we start with Estonia and we start with Piibe Lehtsaar and the conversation about key developments in merger control in our country. So please, Piibe, attention is all yours.
Good morning. Merger control should be a comfortably familiar concept for many of today's participants. However, even merger control is not immune to change. I know that we advertise developments in Estonia, Latvia and Lithuania, but I will take a couple of minutes to talk about developments at the EU level as well. This is because the developments at the EU level have an impact also on transactions in Estonia, Latvia and Lithuania. The general worrisome trend in EU merger control is the increase in legal uncertainty. The first decrease in legal certainty is related to the so-called killer acquisitions. Killer acquisitions are acquisitions of promising small companies by large companies with significant market power. Imagine Facebook, Amazon, or Google acquiring a small innovative tech startup, or a pharmaceutical giant acquiring a competitor who is developing a promising competing drug. In these examples, the target either does not have any turnover yet, or has a small turnover that does not exceed the merger notification thresholds. Since these transactions could still have a significant negative effect on competition, the Commission changed its interpretation of the EU merger regulation in March 2021. According to the new interpretation, EU member states can ask the Commission to review transactions that are below the merger notification thresholds, even in individual member states. And the member states made good use of this new interpretation already in April 2021. As a result, the Commission investigated the acquisition of Grail by Illumina. Both Grail and Illumina produce tests that can be used to detect cancer. Grail is a small company with almost no turnover, but was acquired for several billion euros. The Commission ended up prohibiting the transaction. Illumina is now fighting the prohibition decision, as well as the new interpretation of the EU merger regulation in the Court of Justice of the European Union. While the legal battle is not over, the Commission's interpretation stands. So what does it mean for the Baltic companies? Local innovative startups, especially in the digital economy or the pharmaceutical sector, may theoretically face the risk of EU merger control in case of acquisition by a global group that has a large market share. The second decrease in legal certainty is related to the possibility that an M&A transaction may be investigated as a potential abuse of a dominant position. The Court of Justice of the European Union confirmed this possibility just very recently in its 16th of March 2023 Towercast judgment. This is a French case concerning the broadcast market. The dominant player on the market acquired one of the two smaller competitors. The transaction was below the merger notification thresholds. What the remaining smaller competitor, Towercast, did, they filed a complaint with the French Competition Authority to investigate whether the transaction could qualify as an abuse of a dominant position. The French Competition Authority did not agree that an M&A transaction could be investigated as a potential abuse of a dominant position. However, the Court of Justice of the European Union confirmed that an M&A transaction can be investigated as a potential abuse of a dominant position if the transaction is not subject to merger control. And we already know that the Belgian Competition Authority has initiated an investigation of an M&A transaction as a potential abuse of a dominant position after the 16th of March judgment came out from the Court of Justice of the EU. So what it means for the Baltic companies. Dominant companies who acquire smaller competitors below the merger notification thresholds could find themselves investigated for abuses of a dominant position. This is perhaps most relevant for Estonia, where the competition authority currently does not have the possibility to call in below threshold mergers that could significantly impede competition. But even in Latvia and Lithuania, it might be interesting for the authorities to investigate M&A transactions under abuse of dominance rules. This is because their call-in powers under merger control rules are limited to 12 months after implementation. But the limitation periods for investigating abuses of a dominant position are significantly longer. I am now moving on to the developments in Estonian merger control. Firstly, the Estonian Competition Authority got a new Director General last August. She has been more involved in merger control cases than her predecessor. This has meant longer merger control proceedings. The average duration of Phase 1 proceedings before August 2022 was below 20 calendar days, at least in 2022. I didn't make calculations for earlier periods. Since August 2022, Phase 1 proceedings have taken on average 27 calendar days, which is only slightly less than the maximum allowed duration of 30 calendar days. It remains to be seen if this is a permanent change or once the new Director General settles in, the merger control proceedings will get speedier again. Secondly, Estonia had a few high-profile M&A transactions that were below the merger notification thresholds and could not be investigated under merger control rules, despite the public concerns about their effects on competition. One of these transactions was the acquisition of the largest cinema in Tallinn by Apollo, who already operated most of the bigger cinemas in Tallinn. As a result, the Competition Authority reactivated its campaign for changes to the Estonian merger control rules. The authority has already asked for the right to call in transactions that are below the turnover thresholds but could significantly impede competition. The authority has also asked for changes that would prohibit the initial purchaser from acquiring even minority shareholdings in the target if the authority refuses to clear the acquisition of control or the purchaser withdraws the notification to avoid a prohibition decision. So far, the Minister of Justice has not published any draft law to introduce these changes to the Competition Act. In the meantime, the authority could make use of the possibility to investigate below notification threshold M&A transactions as potential abuses of a dominant position. Granted, this works only for the transactions where the acquiring party already has a dominant position prior to the transaction and is significantly strengthening this dominant position with the transaction. And thirdly, the number of Phase 2 proceedings was on the rise in 2022. Phase 2 proceedings last significantly longer and require significantly more resources and market analysis than Phase 1 proceedings. There is also a risk that the proceedings end in a prohibition decision or the parties have to offer commitments to achieve a clearance decision. Some statistics. Out of the merger notifications submitted in 2022, 6 notifications were examined in Phase 2. Out of these 6 notifications, only 1 ended with an unconditional clearance decision. I note that 1 notification is still under review. It is also a popular choice to withdraw a merger notification when it is clear that the authority will not make an unconditional clearance decision. 2 notifications were withdrawn in Phase 2 after more than 3 months of proceedings. Estonian Post waited until the bitter end and received a prohibition decision after 223 days of proceedings. This slide here visualizes the impact that the initiation of Phase 2 proceedings has on the duration of the merger control proceedings. In 2022, the average duration of Phase 2 proceedings was 138.8 days, which is approximately 4.5 months. And since we are talking about recent developments in Estonian merger control, there have been very few merger notifications filed since November last year. January and February this year were without any notifications. I checked, and the last time that Estonia had a month without any merger notifications filed was in April 2020, and before that in September 2015. So 2 months in a row at the beginning of the year is definitely unusual for Estonia. It remains to be seen if the 2 notifications in March mean that the trend is turning. And this concludes my overview of the developments and lessons learned in Estonia. My good colleague Marika will continue with news from Latvia.
Thank you, Piibe. I think news from Latvia are less exciting as I have mentioned in this slide. We have not have any major changes in our laws which apply to merger control regulations since 2016. So everything is peaceful from that perspective. And if something new or interesting could be added, then Competition Council have published its annual priorities for this year. And as one of priorities is mentioned IT tool, which Competition Council is working on, which should ease process for notification for the companies. So we don't have information on how this will look like and how it will work, but at least the idea is that it will be available online, as I understand, as a digital tool and would facilitate faster and more efficient process. Yeah, and if we look on our statistics in Latvia, then I think in Latvia, compared to other Baltic countries, we have had the most small number of notifications. Last year in 2002, 20 transactions were notified to the Competition Council, and from this slide, you see that there was no prohibitions. All notifications were allowed, but here we have pointed out those which were phase 2. It means that more complicated cases, and from those phase 2 merger reviews, 2 resulted in merger clearings with applying commitments, and 5 were cleared without applying any commitments to the parties. Yeah, and here you can also see statistics for Latvian merger control. You just saw that in Estonia the highest number was 9. In Latvia the highest number has been 3, and also only in 2 months where the notifications were 3. Otherwise, we have also had some empty months in February and August where there was no notifications. But all in all, yeah, the number is not very high. Maybe it is because of merger notification thresholds, or maybe due to after COVID when market maybe is a bit slower. But yeah, this is picture of this year. So I think that's all for Latvia, and I can give floor now to Lithuanian colleague Monika to update about Lithuania. Thank you.
Thank you very much, Marika. Thank you very much, Piibe, and the rest of the guys for sharing your knowledge on the topics. If you thought that Estonia is exciting, wait until you hear about Lithuania and what's going on in the merger field here locally. Since the time is of essence in business transactions, I will spend the majority of my presentation, the next 20-25 minutes, talking about time and what has been going on in the Lithuanian merger control time-wise, and what kind of implications this might have on business transactions, and what should be taken into account before entering into actually any transaction. So this is the general overview how Lithuania looked like in 2022. We had in total 19 decisions related to merger notifications. 17 were clearances and 2 were prohibitions, differently than in other countries. For instance, Latvia, there were no prohibitions last year. Also, out of these 19 cases, 5 were those where the authority had to complete very thorough market investigation, and which took a lot of time for the authority as well as for the transaction participants. And here's a general overview of those second phase so-called transactions, which take more than 1 month to be cleared. And here we see those 2 prohibitions, and one case was cleared with the remedies or commitments, as we call them. And now I would like to move on to the, let's say, more content of my presentation, and to talk about developments. What kind of trends do we see in Lithuanian merger market? And first of all, I would like to start from the amounts of information that are being requested from the merging parties, and about the fee of the merger filing. And maybe I will start from the fee. So some of you might know that since March of this year, the merger examination fee has increased substantially. And currently it is 22,700 euro. And actually, I do not know another jurisdiction close by where the fee would be that high. In comparison, in Latvia, the fee is from 2,000 to 8,000 euro. In Estonia, the fee is from 1,920 euro, and the European Commission does not take any fees for the merger filings. So really, Lithuania is a champion in this sense, and I think it is an important development for businesses to know, especially when we are talking about quite small transactions money-wise. And coming back to the requested information, or the amount of requested information, the trend that we see is that the authority is requesting way more than actually one could read. One could have an opinion just by reading the law. And the trend in this sense is that the authority is very keen on getting as much internal information from the parties as possible. And the authority is formulating very wide requests to provide the information, for instance, to provide in whatever format information related to the transaction, to the potential competition aspects of the transaction, etc., etc. And in practice, this causes a lot of issues because it's not very clear what has to be provided, actually. On the one hand, the authority says that, well, we cannot list specifically what we should be getting because the merging parties know best what they have. But at the same time, since the parties risk to get a penalty up to 1% from the general turnover for non-provision of all information requested by the authority, I think it would be very good if the authority could make more concrete requests for information. Currently, there were cases where the parties, in a way, said that they have provided everything what they thought is necessary for the authority, and then the authority performed the downgrade. They found some more information, and currently we have a court case in this sense. But from practical perspective, it might be very difficult to provide everything related to the transaction because this basically covers any email exchange among the employees. Some of them might have already left the companies. It might cover actually different variants of the same document, for instance, presentations to the board. And if something minor has changed, theoretically, it would also fall under the request. So taking into account the request of information by the authority very seriously is, let's say, the first tip that I could give, and a very clear trend that we see that those amounts of information requested by the LCC are increasing significantly. In addition, I would like to mention that the authority has published recommendations how to submit merger notifications, and these are mostly practical tips and tricks related to how the annexes should be prepared, how we should inform the authority about the fact that we will submit a merger notification and similar. In practice, again, this creates way more work for the lawyers, for lawyers working on the merger filings, and cost more for the businesses. But this is also, let's say, something that you should have in mind. And our advice is to generally follow the recommendations, because this is how then the authority thinks that the notification is prepared properly. It's not something, it's not that the parties have an obligation to follow it, but among the lines, we understand that it would be very good to follow the recommendations and not to raise unneeded concerns. Another trend in this slide that I would like to mention is that the authority has no criterion how big the relevant market has to be in order it went very deeply into it. And in practice, we have situations where the authority has established competition concerns in the Lithuanian market of cheap pasta, or where the authority established concerns in local markets related to specific type of doctors. And even though in the overall transaction, or even though in the overall revenue structure of the parties, it seemed like a totally insignificant activity and totally insignificant revenue part, still the authority said that we don't want to discriminate any of the customers, and we will evaluate even very tiny relevant markets if we see any competition concerns. And I would like to move on then to the next slide, talking about the timing issues. All what I have mentioned until now also is related to the timing, but now coming to concrete figures. So according to the statistics published by the Lithuanian Competition Council, on average, straightforward competition clearances were received in 19 business days, which is almost a month, what is established in the law, and more complicated transactions were cleared within 6 months or 120 business days. However, these terms do not take into account two very important aspects. One is the pre-notification period, and another the stop the clock period. For the pre-notification, there are no requirements time-wise, and from our practice, pre-notifications can take from a couple of weeks to 6 months. So basically, we should sometimes add these substantial amounts of time to this, let's say, statistical merger clearance process length. And stop the clock is a, let's say, mechanism that the authority may use when it considers that some additional information should be submitted and the parties fail to submit it in the timely manner. And in practice, the proceeding should not be stopped more than for 3 months. But theoretically, this means that the authority has the possibility to stop the proceedings, merger clearance proceedings, for up to 3 months until the parties provide this information. And when we are talking about complex cases here in this slide, this means not only those cases where there are some potential competition law concerns, but also those cases where the authority sees that there is no publicly available reliable data. And this means that the authority needs to go to the market, it needs to send out surveys and receive additional information needed for the merger notification. Continuing about the stop the clock procedure. Yes, and why stop the clock procedure actually comes into play or is important is that because according to our law, the authority can provide parties 1 business day to respond to the request for information. And sometimes responding to the request for information within 1 business day is totally unrealistic in practice. And then the authority potentially has the possibility to impose this stop the clock procedure, meaning that the official term is not going to an end and overall proceedings will be longer. Also, authorities sometimes request for some information that the parties are not gathering, or request in such a way that the parties are not gathering the requested data, which also takes time. And this might be additional reason why the stop the clock procedure comes into play. And here are just several examples of how the authority used the stop the clock procedure in practice. And here I will just mention one of the cases was related to the cinema acquisition, the Baltic acquisition already mentioned by Piibe in her presentation. So this was also notified in Lithuania. However, the no clearance decision was made because the stop the clock, this is the only case where the authority used the maximum, let's say, term for the stop the clock and had to suspend or cancel, the procedures, because the party did not submit any requested information by the authority. Then second case is the one that I mentioned with a cheap pasta, a problematic small market, and where the authority found some issues and they actually decided not to issue a major clearance. And here also we had the stop the clock procedure, which resulted in 8 months transaction. And the last one is also the one mentioned by me in very specific problems in local certain doctors markets, where also stop the clock procedure resulted in 9 months measured examination. And one more aspect that I would like to mention under this part of my presentation is that differently than in Estonia, the Lithuanian Competition Council can review mergers, transactions, even though the thresholds are not met. Meaning that if the authority gets some information that some competition concerns are created and the transaction was not notified to the Competition Council because no thresholds were met, it still can oblige the companies to file for a merger notification, and the processes can end in both ways. Either the clearance is issued or the authority decides not to grant a merger clearance. And here we have very recent 2 examples. One in ticket market where 2 competitors merged, and they did not have to notify the authority because due to COVID, the revenue dropped significantly as there were no events and no tickets had to be sold. And another reviewed transaction was related to the elevators, or technical support of elevators, and it's still under review. We don't know how it will end. The authority has to use this right within 12 months after the transaction is closed. And the worst thing is that if the authority decides to not to issue a merger clearance, it also obliges the parties to restore back the situation into the previous condition, which in reality is a terribly problematic thing to do, because imagine if the businesses have closed the transaction, they have started in integration or have even completed the integration, and then within the 12 months period, the authority comes and says, please notify us about this transaction, and finally they decide that no merger clearance can be issued. It's a very difficult thing to do, to find somebody who would buy this part of the business, for instance, that causes problems, or to somehow convince the old owner to buy back the business that has been already sold. And having in mind all of these aspects that I have discussed, I would like to move on to the second part of my presentation. And what do these recent trends that we have discussed, all 3 of us have discussed previously, have on M&A activities, and what things should be taken into consideration when planning an M&A activities, when planning an M&A transaction. So as we have talked quite a lot about possible outcomes of merger control, how long it can take, that it can end in various ways. The notification may not be granted, or it may be granted with certain commitments. For example, divestment of businesses. The authorities may oblige the companies to divest part of the businesses. Then there are really, we see that the merger control proceedings have a huge impact on the overall transaction. And it is quite established practice that merger clearances become one of the key conditions to move to the closing of the transaction. But from the practical perspective, we see that not always agreeing parties understand how long actually it will take to get those clearances, and not always parties make their homework properly in order to do maximum they can to safeguard that the merger clearance will be issued at all. Of course, we see also positive trends, especially from more experienced players such as investment funds. They're really looking into transactions more seriously. They are preparing their homework, performing competitive assessments, consulting with competition lawyers and competition economists. But certainly it's not a 100% practice yet. And everything what we have mentioned, it is very important because merger filing and actually FDI filings as well, or what we have heard previously, they have a huge impact on the transaction, for the transaction planning, for the negotiations, what has to be negotiated, and also for the costs, because those proceedings can increase the transaction cost significantly. I actually see one question on the Q&A. I just want to ask Kaupo, maybe do you think it would be a good time just to quickly respond to the question?
Yes, the questions are coming in, and
okay.
So which way you prefer? But
okay.
The question actually came from Lithuanian rules that sometimes transactions can be subordinated to merger review retrospectively, even if the merger thresholds are not met.
Yeah.
That sounds awfully intrusive procedure. But can you give some kind of yellow lights or identifiers which would help us to understand which transactions might suffer from this activity?
Sure. So I will start maybe from the fact that even in the situations when we see that the turnover thresholds in Lithuania are not met, I would really advise to still perform some sort of competitive assessment. And during that competitive assessment, it is very important to assess how the relevant markets could be defined and how do they look. How many players are on those markets? What kind of market shares do they have? What would be the impact of the transaction? Could it cause any competition concerns? For example, formulate one huge undertaking, or formulate or cause one party having in its hands the whole production and distribution channel, which might also be a vertical, let's say, problem. So, of course, market share is an important factor that we have to look into. In the law, we have a presumption of dominance where the market share is 40% or above. In retail markets, it is 30% and above. So if you see these figures, it should also trigger, let's say, some yellow lights for the merging parties. But it's not only that, as I mentioned, we still have to look at the whole market structure, at the type of agreements that are being made or no. But my advice would be always consult with some competition lawyers, even though when you do not see that the thresholds are not met. In practice, what has happened is that competitors, customers, suppliers, they know that the change has taken place. Plus, this information is public on the public registers, becomes public. Also, sometimes the parties, without thinking that something might be wrong, advertises certain transactions. They want to show that something happened. And actually, these type of situations trigger the authority's interest in checking more, in checking what has happened. And the authority was quite successful in actually catching such transactions which were below thresholds, identifying certain problems, and then, investigating whether the transaction could have happened or not. So that would be my, let's say, general advice. If you see that somebody might be unhappy about the transaction and you yourself feel that it might have some competition concerns, even if those are on very, very tiny relevant markets, I would advise to do the competitive assessment and to consider what to do.
Yeah, thank you.
Now moving on to the next slide, please. We have made some small, let's say, general tips for, let's say, more straightforward transactions, and then to the transactions that are more complicated, as we call them. So even in those straightforward deals, what I have mentioned in a way, we really advise to involve a competition lawyer early in order to understand, to diagnose the situation, because it would be way worse if the parties go into transaction, invest a lot of money, and invest a lot of time, and finally they understand that they cannot do the transaction, either because the clearance is not issued, or because the authority says that you can take over only part of business, but not that essential part that actually the acquirer was interested in, or if the authority decides that it can use its right to review the unnotifiable transactions. So involving a competition lawyer early is really important, even in straightforward deals. It might be important because sometimes from our experience, straightforward deals seem not to be that straightforward after we have a look at them. You know, coming back to the timing aspect, in the laws we have like formal deadlines when the merger clearances should be issued. But in the very last slide of this presentation, you will see what are the realistic merger clearance deadlines, having in mind the time needed for the drafting of the notification, examination, and pre-notification proceedings if these are taking place. So it's really important to realistically understand what the long stop dates included in the SPAs should be. And it's definitely not those terms that are included in the laws and that formally should be applied, because in reality, they do not apply. What is also very important is to prepare really good quality notifications. And here there is no other advice than to involve such external advisors who have previous experience in dealing with merger clearances, know what the authorities are expecting, and can provide really fully high quality merger notifications to the authority. Going to a bit more complex deals, in addition to what I have previously mentioned, it's also very important to do other homework properly. And as I mentioned, the competitive assessment aspect is very important, just to understand where your weaknesses are and what will the businesses do if those weaknesses are also established by the competition authorities. In those cases where there is no reliable publicly available data, it might be also worth considering initiating some information gathering in advance in order not to delay the proceedings later on. And also, in some of the cases where the markets are, I don't know, innovative, not known to the authorities, or it's clear that the businesses have to give extra explanations rather than just pure data, it might be also important to initiate pre-notification discussions with the authorities, to organize meetings, and you know, to safeguard that information that will be provided in writing will be understood properly and will not be just assessed very formally. Another trend that we see, and from that we formulated a tip, is to consider involving competition economists, and doing so really in the initial stages of the transaction. We see that more complex merger cases are examined mostly by economists rather than by lawyers. And it's really easier for them to communicate in the same language. Plus, economic arguments, they always add extra value to the legal ones. So even though it might seem quite costly in the first place, it might be the needed measure in the overall transaction, because the competition economists, they really sometimes make miracles. And I would be really in favor of discussing and considering whether competition economists team are needed in a certain case or not. Also, in those cases where potentially some commitments might be needed, it would be also advisable to think in advance about the divestment possibilities and the trustee. And why we are thinking about divestment rather than other types of commitments is that in practice, the authorities, they really very rarely accept behavioral commitments. In other words, they really rarely trust that that businesses say that they will not do one or another action, and that's enough to clear the merger. Usually, you have to divest part of your business to somebody else to ensure that there will be no competition concerns. And this might be this might have a huge impact on the pricing of the transaction, on the whole wish to go into transaction, actually, because if the authority says that you have to divest that part of business that the acquirer was actually interested in, then it's maybe a clear answer that there is no need to go into this transaction in the first place, and to save time and money in the very beginning. When it comes to the candidates for a trustee, we see a trend that sometimes it might be difficult to find the proper trustee who has the needed experience and does not have a conflict of interest. Because the authorities, they sometimes tend to say that if the trustee has previously provided any services for a fee, then it might have a conflict of interest and cannot perform this function, because it has to be in a way uninfluenced by the merging party. So our advice, having in mind all of this, is to think about the possible outcomes of the transaction in the very beginning and to negotiate your agreements accordingly. For example, how will the merging parties divide the risk of bad ending, whatever that means in a specific situation, be it a delay of proceedings, be it a merger clearance with commitments or denial of the merger clearance. What are the alternatives, and is it okay for the businesses to divest part of the acquired business, and how would that influence the transaction pricing? And very important aspect that we have also encountered in practice is to negotiate your agreements with financing institutions, because if the proceedings take too long, paying interest for the sum that you have borrowed might be also very, very costly. And this is also something that businesses should take in mind in the very beginning and have those agreements negotiated. And moving on to the very last slide of my presentation, here are, let's say, the general or our the terms based on our recent experience, how much the businesses should plan for the deals in our jurisdictions. And here, unfortunately, Lithuania is in a way the champion again, because even though talking about more complex deals, and these, which I have mentioned, are not only those that cause competition concerns, but also might not have relevant publicly available data, which is time-consuming to collect and then analyze. In reality, it may take from 1 year to 1.5 years, starting from the drafting moment until the clearance decision is received. So really, competition lawyers could also help you plan timing of the transactions in advance, because they would know what the current trends in the authorities are, and could advise you what is the realistic term for a merger clearance, given that it's realistic to receive it at all. And as you see in Estonia and Latvia, the situation is a bit better, up to 2 months, 2.5 months for simple deals, up to 7 or 8 months for complex deals in Latvia, and approximately 1.5 to 2 months for simple deals in Estonia, and approximately from 4 to 8 months, which is quite a huge gap, but still gives some indication for complicated deals in Estonia. So that was it, what I wanted to say about the trends and possible impacts for the transactions. And now I give the floor to my colleague Piibe.
Greetings again. This topic is new for everyone because the foreign subsidies regulation was adopted just at the end of last year. It introduces a brand new instrument for dealing with distortions in the internal market that are caused by foreign subsidies. The EU already has state aid rules, but these apply only to subsidies given by the EU member states. This new regulation is aimed at preventing or at least mitigating distortions caused by undertakings who benefit from subsidies received from non-EU countries and who engage in economic activity in the EU. The authority enforcing the new rules on distortive foreign subsidies is the European Commission. There are essentially three enforcement tools introduced by the regulation. All these tools operate in parallel to the FDI and merger control regimes. This means that the transaction parties may have to file separately for merger clearances, FDI clearances, and the foreign subsidies clearance. A small consolation is that the foreign subsidies filing can be made only to the European Commission, whereas merger and FDI filings may be needed in several jurisdictions. The most relevant enforcement tool for today's webinar is the obligation for companies to notify certain M&A transactions to the Commission for prior review. Only M&A transactions that qualify as concentrations or mergers and also exceed notification thresholds need to be notified to the Commission without the Commission requesting the notification. However, the Commission has the right to ask for a notification even if the thresholds are not exceeded. In case the transaction needs to be notified to the Commission, the parties are prohibited from closing the transaction until the end of the Commission's proceedings. This prohibition is called a standstill obligation. Violation of this obligation would result in significant fines. The notification requirement applies only to transactions signed on or after the 12th of July this year, and if the parties do not manage to close the transaction before the 12th of October 2023. So definitely, if you are above the thresholds and are not closing your transaction before the 12th of October, but have signed it after 12th of July, then the notification obligation applies. The second enforcement tool is the obligation for companies to notify to the Commission participation in public procurement procedures. This notification obligation is also subject to thresholds. The Commission also has the right to ask for a notification even if the thresholds are not exceeded. Here, the contracting authority or contracting entity may not award the contract before the end of the Commission's proceedings. And the third enforcement tool that the Commission has is the right to start investigations on its own initiative if it suspects that distortive foreign subsidies may be involved. These investigations may end with a decision that orders the concerned parties to take certain measures to achieve a lesser distortion or mitigate the effects of the distortion caused by the foreign subsidy. For example, the Commission could require the undertaking to reverse an M&A transaction. For concentrations, the relevant thresholds are related to turnover in the EU and the total amount of foreign financial contributions received by the parties 3 years prior to signing. I will not go into the details of the thresholds. In very simple terms, the EU turnover has to be above 500 million euros, and the amount of foreign financial contributions has to be above 50 million euros. When calculating the turnovers and financial contributions, it is extremely important to calculate them at the group level for each party and not just for the legal entity that's participating in the transaction. The 50 million euro threshold for foreign financial contributions seems like a high threshold. However, the term financial contribution is extremely wide. When identifying financial contributions, all transactions with public authorities of non-EU countries need to be taken into account. This includes transactions with public and private entities whose action is attributable to a non-EU country. For example, getting a loan from a state-owned bank in a non-EU country would be a foreign financial contribution. Overall, financial contributions can be divided into 3 groups. The first group covers all and any transfers of funds or liabilities, for example, capital injections, loans, guarantees, fiscal incentives, state-funded research. The second group covers foregoing of revenue that is otherwise due. Here, the best example is a tax exemption. And the third group covers provision and purchase of goods and services. This means all and any goods and services, even if the sale and purchase takes place on market terms. For example, turnover from selling vehicles to public authorities would need to be taken into account as a financial contribution. When we talk about impact, most Baltic companies are likely to be unaffected because of the 500 million euro turnover threshold. There simply aren't that many companies headquartered in the Baltics whose turnover exceeds 500 million euros. Most Baltic companies are likely to be unaffected also because of the 50 million euro foreign financial contribution threshold. It is more likely to be an issue in case a Baltic company is acquired by or merging with a company group that has extensive activities, sales, or purchases outside the EU. To illustrate the likely limited effect that the foreign subsidies regulation will have on Baltic companies, the European Commission itself estimated in 2021 that there could be approximately 26 to 38 transactions in the EU that would need to be notified under the regime each year. Although there are concerns that the Commission has underestimated this number, the impact on Baltic companies should still be very limited. Having said that, all companies that have relations with non-EU countries or entities located outside the EU should have a system in place for tracking all foreign financial contributions received by their group companies anywhere in the world. The register of foreign financial contributions should go back 5 years from the 12th of July 2023 and be constantly updated from that point forward. Since the Commission is entitled to investigate foreign subsidies that are granted up to 10 years ago, data on the register should be retained for 10 years. I note that having such a registry is not a legislative requirement. It is useful to have the registry since information about foreign financial contributions may be needed in future transactions or in case of participating in public procurements. The Commission may also ask for such information, for example, when conducting market investigations into specific sectors. If this information has not been gathered on a continuous basis, it will be difficult to collect accurate data retroactively. We also recommend assessing foreign subsidy risks before accepting any financial contributions from non-EU countries. For example, getting a big research grant from a non-EU country may mean that future participation in big public procurement procedures in the EU may require a prior notification to the European Commission. So checking whether a foreign subsidies filing is needed should be a part of every due diligence process for M&A transactions that take place after 12th of July this year. It is also advisable to regulate in the transaction documents what will be the contractual consequences if the Commission should decide to investigate the transaction, despite it being below the notification thresholds. Some questions to think about. Who bears the risk? Who bears the costs? Should there be a right to withdraw from the transaction if an investigation is started, the investigation lasts for too long, or it ends unfavorably for any of the parties? And the party should also add representations and warranties related to the foreign subsidies regime in the transaction documents. So overall, the foreign subsidies regime is one more topic that needs attention when contemplating an M&A transaction. And this concludes my presentation. Thank you for listening, and may knowledge guide you.
Thank you, Piibe. And may knowledge guide us all. That's a good wish. Just a kind of one question regarding this foreign subsidies regime, which is a new thing for everybody, including myself. While listening to a presentation, am I right to conclude that this instrument is pretty similar to European Union state aid rules, but whereas state aid rules are intended to assure that the market has a level playing field between the member states and companies originating from different member states, then foreign subsidies regime is intended to control situations where, for instance, US companies have developed a service or a huge product thanks to government subsidies and government aid, and then try to spill over these benefits to the more commercial marketplace in the European Union. So it's like a international or transatlantic, transcontinental state aid regime.
Well, yes, Kaupo, you are correct, although the concern, of course, wasn't mainly the US giving subsidies to companies operating in the US and outside the US. It's always China who is the source of all thoughts about new regulations. So, but yes, it doesn't operate the same way as the EU state aid rules, but it's trying to make sure that if there are significantly large subsidies given outside the EU and these undertakings come to participate in public procurements in the EU or acquiring significant market players in the EU, that they would have to get prior approval from the European Commission.
Yeah, indeed. It's understandable that geopolitics then is China, but still, when looking at the thresholds, then when you think about, for instance, about procurement in defense sector, then these thresholds can be easily met, and this type of when we buy defense equipment, then it tends to be US, and there these levels of support by the government for research and development, they're really peanuts. But actually, we have received a few comments or questions about merger filings as well. One topic that Monika touched upon in terms of Lithuania, the commitments. I believe also Estonia and Latvia had a few transactions cleared with commitments. What type of commitments they were? Have the authorities become more kind of acceptable towards accepting or imposing commitments, or what's the market in Estonia? I see Piibe is nicely live.
Well, the Estonian authority doesn't insist upon structural remedies as much as the Lithuanian Competition Authority and also the European Commission does. Historically, it has been possible, at least in Estonia, to get behavioral remedies such as a promise that within 5 years we will not increase prices by more than the increase in the consumer price index or whatever reference index is used. And also, like last year, we only had one commitment decision. In that case, it was a behavioral remedy, and the acquirer had to promise that it's providing access to some essential products to its downstream competitors on non-discriminatory terms. So it isn't that bad in Estonia, but still it depends very much on what the transaction looks like, what the market looks like.
Okay, thank you. Marika, how it looks in Latvia?
Yeah, actually, over the last 2 years, 2001 and 2002, we have had 2 decisions where remedies actually were applied. And both cases, it was related to divestments due to high aggregation of market shares post-merger. And maybe it's interesting to point out one of these cases which relates to the merger between Group and Forum Cinemas decision was adopted in 2001 in summer, but the case is still, so to say, unsolved because the acquiring party was obliged to divest assets, and still this asset divestment hasn't happened because they were not able to find purchasers, and then of course Competition Council also has had to have a time for assessment whether this potential acquirer is in no way related to the previous owners. So yeah, this case is interesting. As I said, decision was adopted in 2001, and still this case is unsolved because already twice the Competition Council has taken decision to prolong the initial deadline for divestment. So yeah.
Okay, thank you, Marika, thank you, Monika, thank you, Piibe, for the overview of the competition law and also the new expected kid in the block foreign subsidies regime. We have actually a few more questions, but essentially we are running out of time. So I'm really grateful for everybody who attended. I hope you found our discussions and presentations interesting, and these presentations they are recorded. They will be published in our YouTube channel, and then we will send you also follow-up materials where you can revisit the materials which you found interesting. So with that, I thank you very much, and see you next time in another seminar organized by Sorainen. Thank you very much, and have a lovely day. Bye.